Welcome to Money Talk with Aaron Ricketts, presented by Ricketts and Associates, 3245 North Adrian Highway, Suite F. The opinions voiced on Money Talk are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, financial or tax advisor prior to investing. Securities are offered through LPL Financial, member FINRA SIPC. Aaron, back with us in the studios here this afternoon. Hey, Aaron.
Hey, John.
Got another great show on tap. What are we going to be talking about?
Well, we're going to talk about what a lot of people don't like to talk about, estate planning. We'll go back to estate planning, and this is something that is kind of near and dear to my heart, something that my father passed along to me in my years of training, and how it's a requirement that we have these documents, and most of us don't.
Yeah.
I say most, the ones that might have more assets or have something like a business or something that they've been working on or through for most of their life, they have a lot of planning documents. Some don't, but a lot do. But there's just, everyday people that really need some of these estate planning documents, legal documents to get them through life, and they're often simple and not expensive, and you can get them done through most attorneys here in the county. They'll take care of that. Most are what we call boilerplate documents, or kind of a fill in the blank. All of these attorneys go to continuing education, and some of them focus on estate planning in their practice, so they'll be more heavy in their education for the year than others. But the documents that they use, they make sure that they're up to date on current state and federal laws. So you should have no problem getting these documents done. And I do a little presentation in my office when I talk about estate planning, especially those that don't have any those that don't have any documents. The question always is, what is estate planning? What does that mean? And my answer is that they're formal written documents. They direct someone to care for you and your assets when you're unable to do so yourself at incapacity and death. So right there, as soon as I start that conversation, it's, we got to talk about being incapacitated or passing away. And often, the women in our lives are much more often caring, and their personalities are that maybe we don't want to talk about this, but it's very, very important to talk about it. I'm not saying that it's only women or always women, but often you have this issue that we can't get past that first line because it's a tough subject to talk about. Usually as we get older, it's, we start having less issues with having that discussion. And sometimes events in our lives trigger the discussion when we have a family member that something happens to them, or we hear, I don't want to call it a horror story, but a difficulty in somebody's life where they didn't have certain documents and they had to go to the court, or they had to hire an attorney, or they had to get professional advice. It might have cost them some money, some time. And it's already often a stressful period when somebody becomes incapacitated or passes away. So why not pre-plan and get this stuff done? So let's talk about it, what these documents are. I say they may include a durable power of attorney or some type of power of attorney, medical patient advocate or a medical power of attorney. Some attorneys use different language in their documents, a will, and or a revocable living trust. So I said a durable power of attorney, medical patient advocate, a will, and a revocable living trust. And there's different types of trusts out there, but I'm going to focus on the revocable living trust. So documents that care for you while you're alive, of those four that I named, are the durable power of attorney and the medical patient advocate. A durable power of attorney is an advocate who cares for your financial and legal affairs. Most of the time, the focus is on your financial affairs. When you can't take care of something yourself, pay some bills, access maybe an account that's in your individual name, you need somebody to be an advocate for you to take care of those things. Durable power of attorney, and you're giving somebody that power to be, in effect, your advocate. An example of an advocate would be, your spouse. Typically, husband and wife will name each other. It could be a sibling, a parent, an adult child, a friend. It has to be just a trusted individual, because I've heard several attorneys, when I'm sitting in their office with clients, they'll say, because it could be the greatest license to steal. People that have become your advocate and they're on there as your power of attorney on that document, they now can act as you, just as you. Now, there's a lot of bad things that happen to people. Not to all people, but some things happen where people commit fraud or embezzle using these documents. So banks, people like me in my business, brokerage firms, and many others, they will really go deep to make sure that that is a legitimate document that you have, and even get the attorney involved that created the document, maybe if it's an older document, to just give a letter just to say, yes, this is the most recent document that we know of, and this person, yes, is the advocate for this person. So just keep that in mind. It has to be a very trusted person. Now, I just have a note here. If a power of attorney takes care of things that you have in your individual name. If you have a joint account, like at a bank, whoever that joint person has access to that account. So your advocate can be a part of that account, but actually that joint person will be the one that can handle those things or take care of those things. So I give the example of like a individual retirement account, an IRA, or your 401k. That has your name on it alone. If you become incapacitated, even your spouse technically doesn't have access to that account. They can't do anything for that account or for you if they need to make a distribution, if they have to do anything that has to do with that account, because it's in your individual name, unless they have a durable power of attorney. So think of those things that it's an easy document to create, and often people will have, let's say you're married, have your spouse as your advocate, but you'll have a backup, say a sibling or even a child, or some people put their parent down. Just keep that in mind. The next document that takes care of you while you're alive is a medical patient advocate, or a medical power of attorney. It's an advocate that makes those health decisions during incapacity. While you're alive, you make your own health decisions, right? But when you can't make those decisions at incapacity, your medical patient advocate steps in. One of the big conversations that goes into creating this document is having a conversation with your advocate about end-of-life decisions, because that is a big part of this document. And usually that's the big discussion when you have, when you create these documents and you have a discussion with that attorney. So again, the patient advocate, just what it says, medical patient advocate, takes care of those health decisions for you when you cannot make them yourself, and also gives them some direction in that document about end-of-life decisions. All right. I said that these are documents while you are alive. Remember that. When you're gone, when you die, these documents cease to exist. No longer in need of a advocate to take care of your affairs, because then something else steps in, and I'll talk about that. But remember too, these are revocable during your lifetime. So as long as you are not incapacitated, any time during your lifetime, you can go back in and make a change. And often we see this when younger people get these documents done. They'll name their spouse or a parent, and then as the parent gets older or passes away, they need to step in and make a primary or secondary change to that advocate. So the other legal name for this would be an advance directive. So what you're doing is you're in advance giving somebody some direction of how things are going to be done. Next document I talked about in my list there is a will. So now we're talking about what documents care for you and your estate after you're gone. So a will does that. It's a simple legal document to express your wishes as how your property will be distributed. It names an executor to manage your estate until the final distribution. So you pass away and there's a process. That executor can be your spouse, a sibling, parent, adult, child, friend, similar to the others that you want to know, that will take care of business, that will get stuff done for you. It names in this document who gets what, right? The distribution schedule. Wills are read in probate court. A will is entered to determine the validity. So you go to probate court, you say, I have this will, and then there's a process that starts, and then the judge will name the executor. Even though you've named one, the judge will say, yes, that person is fit, to do this, or the person says, I don't want to do this. So they have to make sure that an executor is officially named. Creditors are notified and claims are paid. Assets and funds are distributed to the named beneficiaries. An executor makes record to the court for the judge to review and close the case, close the probate. The disadvantages are it may take time. It could be costly. And one of the big conversations that often I just let people know, and attorneys do too, that it becomes a public record. So everybody will know your business for the most part because they can go in and ask for that information. So we talked about the will. Now let's talk about an option to avoid probate, because a will is read in probate. So an option would be to have all your assets, as many as you can, legally as joint ownership, and or naming a beneficiary at your death. So you can name a beneficiary on retirement accounts, insurance policies, annuities, bank accounts, brokerage accounts. You can update a property deed, such as your house, to what they call an enhanced life estate deed. The non-technical term that we use is ladybird deed in our business, which gives you the ability, and again, in my layperson's terms, to name a beneficiary to your home. That's what a lot of people do that for. So you could see if you have a bank account, you can name beneficiaries. If you have IRA, you can name a beneficiary or beneficiaries. And if you have a home, you can name a beneficiary in essence. So there's a way to avoid the probate. You might still have a will just in case there's something out there that needs to be probated, but you could pretty much avoid probate by doing all those things. So a lot of people, as they go through life and create wealth, either through a retirement account or their business, let's say they're farmers, anything that they do that they create wealth, it's possible that they might want a trust or even need a trust. And I'm talking about the revocable living trust. So a trust is a fantastic tool to do many things, but it determines who will manage your estate and assets at incapacity and death. So kind of a little different than the will, right, that just steps in at death. This can manage assets at incapacity too. So anything that's named in the trust, you would name a successor trustee, and that again can be a spouse, sibling, parent, adult child friend, and you can also name a corporate bank trustee. And we have a few in this area that we often refer or let people know that they can use a bank trustee. But the trust simply just determines when and what assets your heirs will receive. So if your spouse is a beneficiary or your children or a charity, it'll name that. So there are ways to avoid probate, which we discussed about doing joint ownership and naming beneficiaries. A trust then can avoid probate because a trust isn't read in probate court, unless there's a lawsuit and stuff goes through, has to go through the probate process. But the idea is to remain away from the court if possible by doing a trust. It's an ability to delay distribution to anyone. So if you want to give your children money, but you don't want them to have, an 18-year-old to have $100,000, $300,000, $500,000 immediately, you can maybe put in your document that they can't get anything till they're 25. And then maybe 5 years later get another percentage, and 10 years get the rest of it. But they could go and petition the trustee, whoever that might be, and say, I got this medical procedure that I want to pay for, and you could have that in their document to say, well, I want them to have this, serious medical procedure. I don't want them to have to wait till 25 to get their money. You could have it for health care, education, and what we call a maintenance of standard of living. So keep those in mind. They're different prices, different costs for all these documents, and typically an attorney will bundle them. So when you go in, if you just get a will, they'll do a durable power of attorney and patient advocate for you and your spouse. And that price is pretty reasonable. You add a trust in and other types of estate planning, the costs start going up. But I think when you turn 18 years old, the best thing you can do is get a durable power of attorney and a medical patient advocate, minimally.
You got some questions. There's a number maybe you could call to get some answers.
Sure. Give me a call, 265-3540.
All right. Thanks, Aaron.
Thanks, John.
That's Money Talk with Aaron Ricketts, presented by Ricketts and Associates, 3245 North Adrian Highway, Suite F. The opinions voiced on Money Talk are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which investments may be appropriate for you, consult with your attorney, accountant, financial, or tax advisor prior to investing. Securities are offered through LPL Financial, member FINRA SIPC. Join us once again next week for Money Talk here on 103.9 WLEN.